Welcome. Welcome to Texas Corporate Law, Jurisdictional Shifts, and the Investor Perspective. This is a webinar that's being featured as part of the Berkeley Forum on Corporate Governance happening on October 28th and 29th in person in San Francisco. And we're just so excited that you're here to join us. We've got an incredible discussion planned today. But before I jump into it, I will give our audience about 10 to 20 more seconds to sign on, and then we'll do a couple of logistics and then we'll get the conversation started. All right. So as folks are rolling in, and if you've been to one of these webinars before, you know how this works. For those who are joining us fresh, well, let me walk you through a couple of things you need to know. First, this is a webinar that's eligible for CLE. We'll drop a link into the chat during the webinar for you to fill out the form. As usual, please stay for the full duration in order to get the credit. So keep a lookout for that link. Separately, we also wanted to let you know some of the other events and webinars coming up. In case you haven't had a chance to register for those, for the Berkeley Forum on Corporate Governance that's happening in person in San Francisco on 28th and 29th this month. We'll drop a link into the chat. If you're interested in attending in person, please do let us know by emailing bclb@law.berkeley.edu with your profile so we can make sure there's room for you, as well as there's a virtual component. So definitely register for that if you can't make it in person. Separately, we also have our next Berkeley Forum webinar, which is the Retail Investor Priorities in 2026. This is a happening space. Retail investors are reshaping valuations, IPO strategies, and even the price of gold. So join us to learn about what they're up to, what we can expect in the next year. This is going to be happening this week, October 16th at 10 a.m. Pacific. You won't want to miss it. We've got an incredible lineup of speakers for that as well. And finally, if you have any questions at all about this webinar, do you want to leave us some feedback, maybe some compliments, just email us at bclb@law.berkeley.edu and we'll be sure to get back to you. With that, I want to pass it over to Professor Stavros Godinas, who is the Faculty Director of Berkeley Center for Law and Business and a Professor of Law and Corporate Governance.
Thank you very much, Anjali. I'm very excited to moderate this webinar and because it's one of the topics that have been dominating conversations in corporate law for the last couple of years. For decades, Delaware has set a benchmark for corporate law. Nevada has long been an alternative, offering an opportunity for those companies seeking, let's say, lighter governance burdens. But now Texas has entered the arena, and the idea with Texas is that it's not imitating Delaware's jurisprudence or Nevada's approach, but it's building a management-friendly model grounded on statutory innovation and on a new business court. So today we'll explore how this is affect competition in corporate law, and we've put together a panel of expert speakers in Texas and in Delaware. So let me start by asking our panelists to introduce ourselves, starting with Roxanne.
Good afternoon, everybody. My name is Roxanne Houtman. I am an attorney with Potter, Anderson, and Caroon. I've spent my entire career there. I've been there for 20 years. My practice is in corporate transactions and corporate governance, M&A, things like that. The other thing I would note is that I am also a member of the Delaware Corporate Council, which is the group of attorneys. There's about 25 of us that are tasked with preparing draft legislation amendments to the DGCL on an annual basis. Thank you.
Great. Thank you very much, Roxanne. Rob?
I'm Rob Vartabedian. I'm a class of 2005 Berkeley alum. I'm a commercial litigator in Texas. I'm the token Texan on the panel today, although I'm going to try to speak in my California accent so that everyone can understand me. I started a litigation boutique with a few other partners about a year and a half ago. Prior to that, I practiced at a large international firm. And my current boutique does all manner of commercial litigation, but principally we litigate in the state of Texas.
Thank you very much, Rob. Welcome. And last but not least, Brad Sorrels.
Yeah, thank you. And it's Brad Sorrels at Wilson Sonsini Goodrich and Rosati, and I'm the other Delawarean on the panel, but I'm a litigator by trade. So I lead Wilson Sonsini's governance litigation practice. I'm sort of housed here in the Delaware office, but I obviously travel across the country and advise boards on Delaware fiduciary duty issues, M&A issues, and so hopefully I'll straddle a little bit of the Delaware environment, but also sort of speak to what we're hearing more broadly in the market, as well as in California.
Great. Thank you all very much. So let's start by setting the scene and talk a little bit about the new business court system in Texas. So, Rob, I wanted to start with you because Texas didn't just amend its statutes, which is something that states have been doing for decades, but it also created a new judicial institution, the Texas Business Courts. So you have practiced there and you have practiced before them. So tell us a little bit about how they're structured and staffed and what's your sense of the culture there?
Sure. So the Texas Business Courts were set into motion about just a little bit over a year ago. There are already over 100 cases in the Texas Business Courts. There ultimately will be plans to have more courts. Currently, there are 5 business courts located in the 5 largest cities in Texas: Houston, Dallas, Fort Worth, Austin, and San Antonio. And there's a court of appeals called the 15th Court of Appeals, which was a new court where the appeals from the business courts go. So far, the buzz is overwhelmingly positive about the business courts. They're a fairly significant departure to what we litigators in Texas were used to in state courts. All judges in the Texas state court system are elected. And in district courts in Texas, outside of the business courts, they don't have any judicial clerks. They don't have an attorney staff working for them. So it's usually a judge and a number of non-attorney staff trying to keep up with sometimes huge caseloads. The business courts are designed to be somewhat of an answer to that, to mimic in many ways Delaware Chancery, to get top tier judges who have excellent attorneys on staff who can have a very quick turnaround on cases. And we're hearing a lot of stories, and I've personally experienced the business courts acting on things in 2 or 3 days that would have taken 2 or 3 months in state courts. Obviously we're only a little bit over a year in, but I think people in Texas are very encouraged with the rollout of the Texas Business Court so far.
So, Brad, as someone who litigates governance cases in Delaware, how does this sound from your perspective? Do you see parallels to what makes Chancery work so spectacularly? Do you see differences? What is your sense?
Yeah, no, and I certainly applaud the effort. I think, having practiced in the court chancery principally for most of my career, having the judge as the trier of fact as opposed to a jury, I think is really critically important, particularly when you're dealing with business issues where, greater level of predictability and certainty is really important. And being able to advise your client on likely outcomes oftentimes can make a huge difference, particularly when you think about things like, should I settle this case or should I not? And so I think that going in that direction is a smart move by Texas. It certainly remains to be seen whether they can, sort of replicate the secret sauce that the Court of Chancery and the Delaware courts have been able to build over the decades. There are obviously smart judges everywhere, and so I think Texas sounds like they're bringing in incredibly credentialed jurists. Delaware is renowned for just having incredibly smart judges. I do think one difference is, Delaware is a smaller bar. The judges oftentimes come from the ranks of Delaware lawyers, and so I think there's more of a common parlance. And so the judges, I think, when they're on the bench, they're very steeped in the Delaware authorities and can able to have that sort of, you get past the superficial issues and really get into the nitty gritty, in the context of arguments and other contexts. And so it remains to be seen whether that can be replicated. And, part of that is, and I know Roxanne, maybe you'll speak to this, part of that is, we just have such a developed body of case law in Delaware that allows us to have that sort of common parlance. And so, are you going to have that necessarily in Texas? I think that remains to be seen.
Roxanne, what do you think about Brad's comments? So one of the issues, something that you hear a lot is that yes, Texas made a huge strides in building the business court system, but it takes a while. How long does it take for a new court to gain legitimacy and be what deal lawyers and boards hope it to be?
I mean, I think from a transaction and I'll address this question solely from a transaction perspective. I think it's hard to predict exactly how long. I can tell you sort of what I think transaction planners, corporate transaction attorneys are going to be looking for. Consistency in the application of the law and the clarity in the decision. When we're doing transaction planning, we understand that there's a certain degree of risk, but we're able to calculate that to some degree because of what Brad mentioned being the sort of large body of case law. We understand what the risks are. We understand where the gray areas are. And we're able to sort of, to some extent, put a calculation on that. And then it's up to the client to decide whether or not that risk is worth it to proceed with a transaction. But we can only do that because we have 100+ years of case law that has been consistently applied over that same period of time. So I think that is something that's just unfortunately going to take time to develop. And I think the other thing that I would say is important from a transactional side, and I think that the Delaware courts have gotten right, is sort of access. And when I say access, I mean, the ability to get a case heard in a timely manner. Very often we don't have the luxury of time. We're running up against an end date in a merger agreement, or there's been some fundamental event that's occurred at the corporate or the board level, and we've got to be able to go in and on a summary basis determine who the composition of the board. And so the ability to do that on a very expedited basis is something that's been critical, I think, from the transactional side. The other thing I think I would say, and this is a little bit, less legal, but I think just under the umbrella of access, just the accessibility of the judges. They're going to be attending Berkeley panels. They're, all over the world on the speaking circuit. And I think that really it's given clients and attorneys an opportunity to get to know them, get to know their judicial philosophy. And more often than not, they're sort of also ruminating on, different fact patterns. So you're able to get a little bit more information about what they're thinking, what they're seeing. And I think that has helped engender a significant degree of trust among the bar, with the judges, but also with the clients. So I think all of that is a long way of saying I think it's just going to take time to develop, whether that's 5 years or 10 years or 50 years, hard to tell. It's just a matter of time.
Yeah, and I'd layer on just 2 quick points on that. And it really is the sort of how are injunctive relief cases going to be handled. Those sort of times you have to go in on a really compressed timeline. And the example I always use with clients is imagine an activism situation where you have an advance notice bylaw that you're trying to enforce, and the ability to either enforce that or to beat down a challenge to enforcing that bylaw in a timely manner, so it doesn't risk your annual meeting date or some action that's coming up. That is critically important. And then the other point is, and we shouldn't lose sight of, the Delaware Supreme Court, which is the immediate court of appeal from the Court of Chancery, also acts very quickly and deliberately on matters. And so you have that certainty in Delaware that you're going to get quick adjudication at the trial court, but then you're also, if necessary, going to have prompt attention at the appellate level.
Sounds great. Rob, I wanted to give you a chance to comment on these remarks before we move on to kind of more specific questions that I had in mind for the three of you.
Sure. I think there's two main points that our Delaware practitioners were raising there. One being, timeliness and efficiency. And I think as the business courts get busier, their timeliness and efficiency may face more difficult tests than they're facing so far. But so far, they've been extremely quick and extremely efficient, both at the business, the trial court level and at the 15th Court of Appeals. So that at least that much so far, I think, is going exactly as planned. In terms of the robust body of case law developed over the course of over 100 years, in terms of some corporate law concepts, including new concepts that are being introduced right now in Texas, obviously there's going to be a process of the case law evolving, and we'll have to see what we get. But of course, like Texas has been around. Texas has had business disputes. Texas has pretty robust business law in a lot of areas, and so it's not like this is all going to be created out of whole cloth. I mean, ultimately, jurisprudence that's been developing over the course of 150 years is going to be available for most types of disputes. How we deal with something like the pre-approval process, we'll just have to see how that turns out in the courts. But there's a lot of case law out there. I litigate in some jurisdictions that don't have much case law of any kind, and I think Delaware practitioners are imagining that practicing corporate litigation in Texas is going to be like that, and I don't think it is going to be like that.
Excellent. So let's move away from the established jurisdiction and go towards the innovations that Texas is trying. And I have to say, as a corporate law professor, having a new jurisdiction and trying new things sounds like a great idea. But for the companies and the practitioners out there, that might not be the case. So let's look at some that are attracting a lot of attention. And given that I have two litigators on the panel, I wanted to start with the one that kind of grabs attention immediately, the derivative suit threshold. So, and this is probably, at least in my mind, one of the most consequential reforms that Texas is trying out. So now Texas is going to allow corporations to set a minimum ownership threshold of up to 3% for public corporations, if I believe, for shareholders to bring derivative actions. So that's kind of a major gatekeeping device. Now, Rob, I wanted to start with you and ask, what was the policy rationale for this? Is it to curb nuisance suits? Is it to protect management from opportunistic litigation? And because this is an opt-in provision, do you see companies opting into that threshold?
Yeah, when it comes to why did Texas do it? I think there's a fairly simple, broad answer to that question when it comes to all this, which is, Texas is doing what it thinks corporations want, and so this is all designed to make the state attractive as a place to incorporate and a place to be headquartered. And so Texas thought this is, yeah, and it's about all of the above. Curbing nuisance suits, making it more difficult to, override decisions that the corporate board is making. And I think it all comes back down to that, to a more efficient, more favorable litigation environment for the corporation. Whether companies are going to opt in, I think remains to be seen. I think some will, and I think that they are going to view this as a pretty significant advantage and something that could give them the ability to avoid a lot of litigation that they consider, troublesome and unnecessary.
So thank you, Rob. Rob started by saying Texas is doing what corporations want. So you're on the transactional side, so I think I'll turn the question back to you and ask, is this what corporations want? Is this in line with Delaware's philosophy of shareholder access to courts? Um, do you see it as a reasonable adjustment? Do you see it as a problem? And where do you think it's going to matter most?
Yeah. Is it what the clients want? Yes, obviously. Yeah, the ability to dispense with nuisance suits. I think it's fair to say that the vast majority of my clients would want that. In terms of, is it in line with Delaware's philosophy, or is this sort of a response to market influences and market developments? I think it's a little bit of both, to be honest. I mean, look, Delaware, of course, has a public policy that favors the ability of stockholders to bring suit to remedy perceived harm. We obviously, take seriously the role of corporate fiduciaries, and sort of the ability of stockholders to assert a lawsuit is sort of one of their, sticks in their bundle of rights. But I think we would all be disingenuous if we didn't acknowledge that there's been a different type of class of, stockholder, quote unquote, who is asserting a lot of these cases, who is seeking to take advantage of situations as they come up, and who's really, I think, whose interests aren't necessarily in line with the interest of the longer term stockholders. So yes, obviously we've all seen what has happened over the last 15, 20 years, and understand sort of the need for some type of middle ground approach to be able to ensure that stockholders have a voice, contrasted against sort of the need of the company to be able to operate without the threat of endless nuisance litigation. In terms of sort of where this goes and what do I think the investor response will be, I think it's all going to be shaking out. I think we're very, very early. Obviously, a number of the large pension funds have come out, expressed concern. But I think, again, it goes back to this is one of the tools, one of the sticks in the bundle of rights. And there is concern about taking that away in some meaningful way.
Exactly. So because it matters to shareholders, and especially it matters to some big shareholders. So I think Brad, the conversation with Rob and Roxanne set out the policy framework for this question very clearly. From a practical perspective, from a litigation perspective that you see every day, what's going to be the effect of that threshold? What would have been the effect of that threshold if it becomes adopted in a widespread manner?
Yeah, and I mean, I think it sort of Rob and Roxanne's comments sort of get to it. The practical effect is it is going to limit litigation. I mean, if you have a 3% cap on derivative claims, I mean, very few stockholders are going to meet that. I mean, even some of the largest pension funds don't come close to that in most public companies. And so you certainly can have sort of aggregation of stockholders to be able to meet that threshold. But I think it's just going to have a more immediate, impact on limiting litigation. I think what you might see is there's going to be more of an effort to sort of cast claims as direct claims that to try to get around this limitation. I mean, fundamentally derivative claims, and this is why I think, to Roxanne's point, sort of balancing the ability of the company to control litigation that does fundamentally belong to the company, right? Derivative claims are claims that are asserted on behalf of the company, and the relief goes back to the company in any given situation. And so I think what you're going to see is people try to plead around that and try to plead direct claims. And you can think of sort of like the typical direct claim is like a disclosure claim. I alluded to the activism situation, that those are often pled in a direct manner. And so I think, direct class action claims probably will be pled more frequently. But it's just all sort of hard to see. And the last thing I'll say on this, and it goes a little bit to sort of what a clients want, obviously there's sort of different perspectives. I'll throw in here the perspective of, venture funds, large investors. I think there is a sort of debate of, is this where we want companies to be if there's going to be no opportunity to pursue these types of claims? And so I think there's certainly a debate going on, not only at companies and amongst our friends who represent plaintiffs in contingent litigation, but there's also the sort of sophisticated investors, venture funds, PE firms, who I think are sitting on the sidelines watching this and thinking about whether or not this is really good at the end of the day from a overall policy perspective.
Great. So this promise is one of the big promises that Texas is making to corporations. The other big promise has to do with the independence of directors. We've seen director independence becoming a central issue in Delaware jurisprudence. They're used to remedy conflicts of interest very extensively. And a lot of important kind of decisions actually turn on are the members of the board committee independent or not. So, and that in Delaware it's a fact-intensive inquiry and gets determined for each question separately. Now, one of the most novel features that Texas is offering to companies is the ability for boards to seek an advance ruling from the court as to whether the special committee is independent or not. And that's something that we don't see in Delaware or Nevada. So, Brad, I'll start with you in this question because you are the litigator who has dealt with countless determinations of independence. I wanted to ask you first to walk us through a little bit through the Chancery Court's fact-based inquiry so that our audience understands the stakes and explain why it has become such a controversial issue in recent years and why this question has ended up as one of the key reforms in this stage reincorporation debate.
Yeah, and I sort of start with, sort of why independence is important. Delaware sort of places significance on decisions by independent directors. I mean, that's a good thing. We want independent directors on boards, deciding issues, ensuring that there isn't bias or conflict in corporate decision making. And so whether it's the demand futility context, right, the question of whether or not the corporation brings a lawsuit against directors or officers, or whether it's in a transactional context, you look to whether a majority of the board is independent, or maybe there's a committee that's formed. Like independence sort of takes a central role. And so necessarily it's oftentimes sort of that threshold question that comes up in litigation. Importantly, Delaware presumes directors to be independent, right? That's our bedrock law. And I think the Delaware courts are also sophisticated, and there's plenty of cases that essentially say, we acknowledge that directors are not going to be strangers, that they're going to have some familiarity. I mean, that's how business works. But because it's such an important question, I think Delaware courts do sort of delve into this. Part of this is also, on motions to dismiss in the court of chancery, the court, oftentimes write 100-page opinions, and they'll delve very deeply into, issues of independence. The other sort of angle on this is it's often coming up at the pleading stage. So it's coming up because the plaintiff has pled facts and the plaintiff gets all reasonable inferences. And so oftentimes the court is sort of just taking on its face the allegations the plaintiffs are making. And part of the sort of more recent, why this is a more recent discussion point, is I think plaintiffs have gotten very good at pleading around facts to assert that directors lack independence. So, things like scouring social media. It's not uncommon now for complaints to have pictures of, some event that was on LinkedIn, or, a picture of someone standing on a boat with their arm around the interested
Yeah.
director. That's a common.
Internet and Musk, there were a lot of allegations of people having been on holidays together, on cruises together. So that was very common. Social media has come from Delaware, I would say, for
Yeah, and
directors.
so it's a little bit, and I also sort of push back a little bit on, it's not so much like a last couple year thing, or it's not even
Mhm.
specific decisions like Tornado and Musk. I mean, I would say just advising boards the last 10 years, I think this is always something that directors sort of, bristle with, this notion that, well, I'm a nominally independent director. I think I'm independent and capable of weighing in on this decision, but I'm being advised by counsel, but maybe there's risk that
Mhm.
because I have, this business relationship that I might not deem to be independent. There's certainly also this dynamic of just as more case law comes out, you see more instances, more examples of relationships that raise that concern. I think that also contributes to that dynamic. But I think, I always sort of like bottom line it with directors. It's like, this is important. This is why we focus on it. But I do think it does create, and I think Roxanne will speak to this, it does create difficulties from a planning perspective because, trying to advise directors and forming a committee and thinking about independence, and you're not going to know whether or not that independence issue is real until you get to litigation. Because oftentimes you're just sort of, you're dealing in gray. You're calling balls and strikes and trying to come up with the best advice you can. And so I think that's really what animated the changes to the Delaware statute, which I'll speak to. And I know we're going to talk a little bit about the Texas statute, but in Delaware, they, in sort of recent amendments in the early part of this year, we adopted specific language, essentially codifying that presumption of independence if the director meets the listing standards, and then providing for a higher bar. It's a particularized and substantial facts to rebut that presumption of independence. And I think that's a little bit going to this idea of like, can we just provide a little bit more certainty, a little bit more predictability for folks as they're, staffing committees and thinking about board votes.
Roxanne, I'll come to you, given that Brad mentioned the recent amendments, and you were in part of the committee that drafted them and discussed them. So tell us a little bit about the thinking and those reforms that Brad mentioned, and how do you think they deal, and what kind of improvements they offer to companies around this question of independence. And then I'll ask you also, would you ever consider, or do you think it's not you personally, but do you think it's a real conversation in Delaware to adopt a similar process to what Texas is doing, ask ex ante definitions of determinations of independence? Then we'll go to Rob and I'll ask Rob how this is playing out in Texas.
Yeah, I can't speak to the deliberations, but I can tell you that the impetus behind this was to provide for a greater degree of certainty. I think in some ways, right, we're trying to get to the same place where I think Texas was trying to get to. We just did it a little bit differently. We codified ours into the statute. I think as Brad sort of explained, we have this now presumption of independence, with a higher burden to overcome or rebut that presumption. But I think if you look at the structure of new 144 as a whole, it's really intended to remove some of the uncertainties that Brad talked about. Sort of the questions sort of perhaps were in gray areas. The whole idea is that we're putting into law these statutory safe harbors that are designed to give transaction planners a greater degree of comfort that as long as they are satisfying sort of the requirements of the statute, the transaction that they've worked so hard to put together and have approved will not be the subject of fiduciary duty litigation. And I think the value to that is hard to we can't hardly sort of quantify that. It's just critically important to clients and to planners alike. I think you also asked sort of, would Delaware ever consider that? I don't know. I will tell you, I think from a transactional perspective, I think it's a novel idea. The ability to go into court and to get a blessing up front from the court as to the independence of a particular director or a committee. I would have never thought of that. I think it's a really interesting idea. I think it will have limited utility in certain areas because I think, there are going to just by design be certain committees that won't lend themselves to this process. Things like where this is not going to be a public process, or we have concerns about sort of having to act expeditiously. You need to form a committee and have a transaction done in 2 weeks. Do you have the time to go into court? Things like that. But I think it's very interesting. Would we consider it? And again, just from my own personal perspective, not ascribing anything to the corporate counsel, I think I would personally be in favor of looking and seeing how it develops in Texas. I think my big fear is, or concern, I would want to get comfort is that, this doesn't sort of become some expected default, that somehow, the failure to go and to have this approved in advance doesn't somehow count against you in litigation, that we don't sort of develop sort of de facto sort of new rules. But it's very interesting, and I think to follow. I will be following along with it.
Mm-hmm. So, Rob, it looks like Texas has captured everyone's imagination with this innovative process. How do you see it working in practice? What is the conversation? I don't know if there have been attempts to go to court and get this advance blessing, as Roxanne said. How are things looking in Texas around this process?
I'm not aware of any attempts yet, and yeah, I agree. I think sounds like a great idea, and like I said earlier, I mean the motivation of all this is just to correct one thing you said earlier. I don't think I said Texas is trying to give corporations what they want. Texas is trying to give corporations what they think corporations want.
Sorry.
Which no, but it could be a big difference, right?
Absolutely.
This sounds like something that a corporation would want.
Mm-hmm.
I mean, I'm involved in litigation situations all the time, or where I'm counseling a client who's afraid they're going to get sued for something, where I think, wouldn't it be nice to just go get an advisory opinion and say, look, if we do it this way, we're fine. But there are just for one thing, I mean, there are issues with advisory opinions in general. There's a reason why they're generally disfavored,
right?
Because you're, naturally going forward in a situation that's not as purely adversarial as a normal litigation would be, where you have someone on the other side who's going to be clearly advocating for the other position. You're dealing in a lot of hypotheticals in a situation where you're seeking pre-approval. It's unclear how confidentiality is going to be dealt with in all of this. I mean, a lot of situations that would require pre-approval, I would think confidentiality would be extremely important, which may be why this isn't getting utilized a ton so far. So it's also a little unclear to me, reading through the statutes, how appeals work. It refers to the ruling of the business courts as being dispositive. What does that mean? That means it can't be appealed to even the 15th Court of Appeals or the Texas Supreme Court? Does it mean the trial court, business court, makes a final decision and that's it? Once they've gone through the process and they've gotten the pre-approval, if the facts seem to shake out a little differently than as was discussed in the pre-approval process, does that mean there's no recourse with the business courts or with the courts of appeals? So that's a long way of saying, sounds extremely convenient, and we don't really know how it's going to work in practice. It's raised a lot of questions within Texas, but I think if it works well, it's a feature that I think other states are going to latch on to. It's just unclear how well it will work and if it's truly a practical solution.
Great. So let me move on to another innovation in Texas, and that has to do with forum selection, arbitration, and jury waivers. So Texas is allowing a lot more flexibility in forum selection, and also allowing the possibility of arbitration. So that can now be written directly into corporate chapters. So, Rob, I wanted to start with you and ask what you're seeing in practice. Are Texas corporations beginning to adopt these Texas exclusive forum clauses or arbitration provisions that push shareholder litigation into arbitration? And before you answer, let me just say that we will have a Q&A session in the end. So I would like to encourage audience to submit questions through our Q&A. We have some questions already, and we'll get to them in a little bit. Rob.
Yeah, we are seeing companies using it. I will go ahead and answer one of the questions in the Q&A. Seems to be related to the waiver topic. Isn't jury trial guaranteed in Texas. It is under Article 1, Section 15, but there was an amendment to that in 1935 that said the right to the jury trial is in all causes in the district courts, which I think can be read to mean if something's gone to arbitration contractually or if it's in the business courts, there's not necessarily a right to a jury trial guaranteed under the Texas Constitution. Probably the most notable company we've seen using forum selection and procedures is X, and the Elon Musk companies. And in fact, they're choosing to litigate everything they can litigate in Tarrant County, which is my home county where Fort Worth, Texas is located. Although they've been mostly using the federal courts in Tarrant County as opposed to the business courts. But I imagine we are going to start seeing some of their proceedings going into the business courts as well. I think, and for a long time, I've actually been encouraging my clients, corporate clients, to use Tarrant County venue selection clauses for a host of reasons. I think the state courts, the business court, and the federal courts in Fort Worth offer a lot of litigation advantages to businesses, and the courts are more efficient than a lot of courts elsewhere in the state. So, yeah, I think those are being utilized. And, aside from incorporation in Texas, obviously we've seen a whole lot of companies headquartered in Texas, and they're taking advantage of, venue and forum selection clauses to end up on their home turf.
So, Brad, now Delaware law doesn't allow for this flexibility at this time. So, how important do you think this reform is going to be for companies to have the ability to push certain issues for shareholder litigation to arbitration?
Yeah, and a couple of things, and I'll even hit one of the questions in the chat, which was to speak to the SB 95. So that was recent legislation where Delaware sort of further modified the provisions that deal with what you can do with forum provisions. And again, the Delaware statutes intend to be broad and enabling, and so it sort of speaks in terms of you can adopt forum provisions for sort of narrow internal corporate claims. There's like internal affairs claims, and then sort of broader intra-corporate claims, and that might include, like, for example, federal securities claims. And the legislature recently amended the latter bucket of claims to say you have to be able to bring it in at least one court in the state. And so it just reflects sort of a policy determination that, you can't foreclose the Delaware courts for claims that will relate to the business and conduct of the affairs of the corporation. I think that would necessarily preclude mandatory arbitration provisions, right? So provisions where only arbitration is the forum. Of course, that enabling statute would allow arbitration to be added as a forum, right? So you could have arbitration in addition to the courts in Delaware, but you can't preclude the courts in Delaware. And it remains to me to be seen how critical this will be for folks looking at this. I mean, I do think it's similar to the 3% cap. I think it might be an attractive, hey, here's a way to materially limit litigation potentially, because you're putting hurdles on the ability of stockholders necessarily to bring litigation when you're forcing it into an arbitral forum. I think there remains to be seen sort of what does stockholder litigation in arbitration look like. I can certainly speak to the sort of the other types of litigation that we see in the Court of Chancery, right? So like put stockholder litigation aside and just the normal business disputes, right? Commercial disputes, earn-out disputes, busted deal litigation. You're trying to enforce a merger agreement. I've done that both in arbitration and in the Court of Chancery. I will tell you, it is way preferable to be in a court than arbitration. Arbitration comes with a lot of benefits in the sense that it's confidential. But there's other dynamics at play. You're dealing with oftentimes a panel of arbitrators or a single arbitrator, and there's less developed authority that necessarily governs that process. Whereas in a court, you've got sort of those very tried and true, whether it be the case law precedent, but also the civil rules of procedure for that court that also govern, in addition to rules of evidence and things like that. That you don't necessarily have as much clarity in arbitration. So it just remains. If I'm again thinking about this from advising companies, I think it's an interesting thing to explore. It's just a little unclear how stockholder litigation and sophisticated commercial litigation is going to play out. If that's where you're ultimately pushing things.
Mhm. Roxanne, when we were talking about the 3% threshold for derivative litigation, you mentioned that some pension funds and other big investors are not very happy with this development. So how do they think about the arbitration clauses or the forum selection clauses?
Yeah, I'll be honest. I haven't heard, I think, as much of a reaction. It's been a little bit more limited. I think because my knowledge, at least, there've been few or not, if any, that have actually moved forward with mandatory arbitration. At least it hasn't hit my radar. But I think there certainly are. I have heard some discussion. I think the concern from an investor perspective is that arbitration is potentially more costly for stockholders. It is less transparent, and I think when I focus on sort of the transparency is look, I think the ability to go into court and to seek a remedy for an actual or perceived harm. I think a lot of investors believe that serves as some type of informal check on overreach by corporate fiduciaries, that should they take a particular action that is inconsistent with their fiduciary obligations, there's this risk of a very public lawsuit, and so it sort of helps keep the balance, and you lose that with arbitration. So you don't have that same degree of transparency, and therefore you don't have that informal check. I think there's just a number of reasons why investors would be wary of this. I think there's certainly understanding when it comes to things like nuisance litigation and trying to sort of stem that. And certainly it's not in the stockholders' best interest because that's just costs that are being incurred and to their detriment. But I expect that there will continue to be some pushback on this. I think a lot is just going to depend on whether or not there's a groundswell of support for this type of provision and whether it is broadly adopted by corporations.
Great. I wanted to come now to some questions from the audience. I'm going to cherry pick some, so apologies to those who don't get their questions discussed. Now, one question is about recommendations by ISS and Glass Lewis, and what do they recommend about a potential move to Texas? How are we think this is shaping up as a broad manner? What are we hearing? What is our sense? Feel free, whoever the panel has information about that, feel free to jump on and comment on the question.
So I don't know, Roxanne, if you know for sure. Go ahead. Yeah.
No, look, I'll be honest. I don't know. I don't know if there's been a formal response by either at this point. I suspect, though, that a lot of this is going to depend. It'll be done on a case-by-case basis and depend on what they see in the corporate charters and bylaws, articles and bylaws. So if there is a 3% limitation requirement for stockholder litigation, if there's mandatory arbration, I think in those instances you're going to be much less likely to get a favorable recommendation from these advisors. But I haven't heard that there's going to that there is as of yet a blanket sort of thumbs up or thumbs down to Texas.
I agree with that.
Great. So another question asks, okay, we've talked about the specifics kind of in the specific provisions and differences between Texas and Delaware. But if I am a CEO or a board chair, why would I want to incorporate in Texas or not? And I wanted to So this is one way of framing the question. Another way of framing the question to add a little more kind of a more practical perspective on it is what kinds of companies do we see uh, finding Texas to be more attractive? Is it large public companies? Is it closely held entities? Is it PE-backed firms? So what is it? Which CEOs, like the question is asked, if I'm a CEO, what should I be thinking? Another way to approach it is, okay, which CEOs, what kind of companies are now thinking of making the move?
Yeah, I mean, the one thing I would just throw in here, because it has been mentioned yet, is Nevada, which is,
Mm-hmm.
I think, in my experience at least, sort of in the public company, large private company space. I think that's where you're seeing a lot of traction. There's the recent announcement from the Andreessen A16 folks, talking about Nevada. So I think that seems to be on a lot of people's radar. So I don't know if and I'd sort of like, I'll stop talking, let it jump in. I don't know if I've seen sort of the profile of who is choosing Texas. Certainly you have Elon Musk and his affiliated companies have chosen Texas, a few other companies, but I don't know. I don't know if there's been sort of a clear profile of, the type of company that chooses Texas over Nevada and obviously Delaware.
Okay. So there's also another question, and I think that's more directed to Rob, which piqued my interest, and I was wondering, Rob, whether you have any thoughts on it. And that has to do with the role of politics in politicians in picking judges. And in Delaware, we have some constitutional provisions around the how judicial officers are picked, and I won't try to explain them, but Roxanne can explain them, I think, more clearly. I've read a lot of papers about them, and that explains my hesitation. But I think Texas, I don't think has a similar system in place. So I was wondering if there have been any questions about politics and political influence over the business courts, Rob.
Well, we have elected
Hmm.
judges, which means that there are large amounts of campaign contributions flowing in. It means that judges are having to campaign for office.
And that
Um,
includes the business court judges as well.
it's right.
Hmm.
And so I think there will always be questions about political influence whenever there are elected judges. Um, what I can say anecdotally is that it did not appear to me that the folks who were chosen to be business court judges, either in the five business courts that are now open or the Court of Appeals, those did not appear to be highly politically motivated. I mean, there are, certain groups within Texas that curry a lot of favor with the current administration in Texas and the Trump administration. And I think there could have been political crowd pleaser choices made in the business courts and in the Court of Appeals. It did not seem to me like they did that. There's not a way of quantifying that other than that I can say the sort of loudest, most politically active people are not the ones who ended up on those benches for the most part. So personally, I think that the governor made those choices because he knew he wanted to appeal to a broader swath of corporations. Also, probably knowing that the Republican base was likely not going to get extremely excited about who did and did not make it on a particular business court. So this wasn't some big red meat issue for the governor. And thought instead, I want to make responsible choices that sophisticated corporations will look and see who were placed on these courts and think this is a person I would trust making major decisions for us.
Yes. Okay. So something that we discussed during the prep calls and we didn't get to it, but I want to make sure that we get to it is how do we measure success? So Texas is now starting out. It has taken the effort and the resources to build a new business court system. It has kind of introduced new vitality in this question of state-to-state competition in corporate law, which was pretty much settled for decades. But as we said, it's still very early days. So if we think ahead 5 years from now, what should we be watching? What metrics should we be watching in order to know whether Texas has succeeded? Are we watching incorporations? Are we watching litigation trends? Are we watching market perception? And what would that look to you in order to say Texas has made an effort that has paid off? Brad, should I start with you? I think I'll start.
I mean, certainly reincorporations is the goal, right? So I think,
Yeah.
From Texas's perspective, I'm sure they're looking at it as, the raw numbers 5 years from now. I look at litigation trends as sort of go in the other direction, which is do the litigation trends prove out sort of the more promissory elements of, the 3% and other procedural mechanisms, does the experience of corporations who have moved to Texas match what they thought they were going to get, and how is that measured in the marketplace? I think that'll tell a lot. That first sort of large stockholder litigation that doesn't come out the way that folks anticipated, I'm sure will resonate for folks who chose to move to Texas. And then I mentioned it earlier. It's not just the stockholder litigation. I mean, that's even if you look at the Court of Chancery, that's a slice of the types of cases. It's these normal commercial disputes. If you have a dispute with another company over any number of issues, are you happy litigating in Texas courts relative to potentially the Court of Chancery?
Yeah, which is something that Rob brought up as well in his comments. So that's a very important marker. Rob, what would success look like from the Texas perspective?
I think I'd look at it like opening a new restaurant. That early on, all you probably care about is the numbers. You want to get a big crowd, and so I do think early on it'll be reincorporations and just looking at the data and are people showing up? Are you getting a big crowd? Of course, the problem with that with a new restaurant, sometimes if a bunch of people show up and it's shitty, then they never come back again and you're done. So longer term, as opposed to just looking at raw numbers, it'll be the handful of big high profile decisions that come down. Do they make sense? Are they fair? Do they make investors freak out because they're so pro corporate that they cause unintended consequences? And then, of course, in the longer term, 10 or 15 years from now, has everybody left Delaware and headed for Texas because they decided it was great, or did this turn out to be, a short-term fad where people were interested in it and wanted to see how it went, but then they settled back into what they were used to for the prior decade? So, yeah, I think initially it's just kind of be analyzed quantitatively, but then longer term, you'll see, giving corporations what they think they want. Were you right, and was it a good idea?
So first, let me say that you're all committed to discussing with me the big corporate law case that comes out of Texas, since you're all considering such a huge marker. So let's make an appointment to discuss this between us, among us. But we only have like a minute and a half before we end it. So I think I can ask you for your quick elevator pitch. Why should I pick Delaware and why should I pick Texas? And I'll start with Roxanne. 30 seconds.
Yeah, I mean, I think, sure. Delaware has been the leader of incorporation, both with the corporate and the alternative entity side for a reason, for 100+ years. It's the well-developed body of case law. It's the experienced jurists, the experienced bar. It's the consistency that we have provided for that long period of time. There are reasons why people have chosen us. There are reasons why people have chosen to stay. We think that will continue for a very long time. We understand that there are going to be market moves. There is always going to be another bright, shiny object. But there are very good reasons why to stay in Delaware, and those have been what you've seen the last 100 years, and we hope you'll see them for the next 100 years.
Rob, elevator pitch. Oh, you're muted, I think.
I'd like to just attack the empty chair, and I'm going to ignore Delaware entirely and talk about Texas versus Nevada. And I don't. I'll focus on people who like shiny things instead of people who like things that are tried and true. So to me, and this is probably because I'm not sophisticated enough, I don't even understand why someone would choose Nevada over Texas. I can understand arguments for Delaware. But if you're thinking about some alternative to Delaware, it seems to me like a state that has far more population, a state that's more favorable from a tax standpoint in most ways to be headquartered. And we actually have a business courts, not like a concept of a business courts. And another thing, when you start drawing from the available jurists in Nevada to fill the business courts and the Court of Appeals in business, I think you'll find you're dealing with a far, far, far thinner pool than we were dealing with in Texas. So I think if those are your, setting aside Delaware, if those are your two choices, then it seems to me like Texas would be the obvious choice.
Great. Brad?
I'll just layer into, as you can imagine, I'll second a lot of what Roxanne said. I mean, there's a reason Delaware has been prominent for so long. I think boards just need to be thoughtful about it and, not be distracted by shiny objects, like 3% caps and the like, and just think about, what's good for broader governance.
Great. I think Angela has come to impose order.
All right, everyone. Solid closing arguments over here. Thank you so much for joining us. I really appreciate you, Brad, Rob, and Roxanne, Stavros. Wonderful conversation. Everyone on the audience, feel free to fill out your CLE form, and we'll see you back on Thursday. Thank you all so much.
Great.
Thank you.
Thank you.
Bye-bye, everyone.
Bye.